Can you sue your fiancé for backing out at the last minute? Find out how the law handles broken wedding promises in the Philippines. This story began with excitement, dreams, and the promise of forever. Francisco Velez and Beatriz Wassmer, deeply in love, were set to tie the knot on September 4th, 1954. Preparations were in full swing, invitations sent, guests invited, and everything ready for their big day. But just 2 days before the wedding, Beatriz received a handwritten note from Francisco saying he had to postpone the wedding because his mother opposed it, and that he was leaving town. The next day, he sent a vague telegram reassuring her that nothing changed, and that he would be returning very soon. After that, Francisco disappeared and never contacted Beatriz again. Left heartbroken and humiliated in full public view, Beatriz took legal action. Francisco failed to respond to the case and was declared in default. After presenting evidence, the court awarded Beatriz 2,000 pesos in actual damages, 25,000 pesos in moral and exemplary damages, and 2,500 pesos in attorney's fees. What began as a story of love ended in abandonment, scandal, and a landmark case on breach of promise to marry. Then, interestingly, on June 21st, 1955, Francisco filed a petition asking the court to set aside the default judgment and grant a new trial, claiming he had been negligent but for excusable reasons. Beatriz moved to strike it out. Instead of ruling right away, the court scheduled a hearing for August 23, 1955, to give both parties a chance to explore a possible amicable settlement, warning that failure to appear would result in the petition being submitted for resolution as is. When the date came, Francisco didn't show up. The next day, his lawyer filed a request to delay the resolution for 2 more weeks, saying he needed to speak with Francisco, who lived in Cagayan de Oro, to discuss the possibility of settling. The court granted the request, but nothing came of it. By June 15, 1956, Beatriz reported that the deadline had long passed, yet neither Francisco nor his lawyer followed through. The court gave them one final chance by calling both parties again on July 13, 1956. This time, Francisco's lawyer admitted that settlement was no longer possible. On July 20, 1956, the court officially denied Francisco's petition. The case was then elevated on appeal. Francisco insisted that he had failed to file an answer only because he believed an amicable settlement was underway, a claim he hoped would excuse his inaction. Francisco tried to cancel the court's decision against him by claiming he had a good reason for not showing up. He said he didn't marry Beatriz because of events beyond his control. But the court said his explanation was too vague and didn't include real facts, just opinions. For a petition like his to be accepted, it must come with clear proof of a valid reason, not just general claims. Francisco also argued that the judgment was invalid because the evidence was presented to the clerk of court instead of the judge. But the rules actually allow that process, especially since Francisco was already declared in default for not responding. He no longer had the right to object. Lastly, Francisco said the ruling was wrong because the law doesn't punish someone for breaking off a promise to marry. While it's true that the law doesn't specifically allow a case for just a broken promise, the court had already decided in earlier cases that if a person backs out of a wedding in a way that causes serious harm or embarrassment, they can still be held responsible. The main issue in this case is whether or not a breach of promise to marry is an actionable wrong that would warrant the award of damages. It's important to remember that just because something isn't against the law doesn't mean a person can get away with it completely. According to Article 21 of the Civil Code, if someone intentionally causes harm to another in a way that goes against morals, good customs, or public decency, they can be held legally responsible. In this case, Beatriz and Francisco applied for a marriage license on August 23, 1954, and set their wedding for September 4th. Invitations had already been printed and sent out. Clothes were bought for the bride and bridal party, and even a matrimonial bed was purchased. Friends and family gave gifts and held bridal showers. Then, just 2 days before the wedding, Francisco left a note saying he had to cancel because his mother was against it. He flew back to Mindanao and sent a telegram the next day saying everything was fine and he'd be back soon. But he never returned and was never heard from again. This wasn't just a simple case of breaking off an engagement. Setting a public wedding, allowing all the preparations and celebrations to happen, then suddenly disappearing right before the ceremony is a serious and humiliating act. It goes against good manners and basic human decency. That's why, under the law, Francisco was held liable for the harm he caused Beatriz. Francisco argued in his petition that the damages awarded to Beatriz were too high. He didn't question the actual expenses she incurred, but he claimed that the 25,000 pesos given as moral and exemplary damages should be removed. However, under Article 2219, paragraph 10 of the Civil Code, moral damages can be awarded in cases like this one, which, as mentioned earlier, fall under Article 21, when someone causes harm in a way that goes against morals or good customs. As for exemplary damages, Francisco said they shouldn't apply because, by law, these are only given if someone acts in a clearly abusive or harmful way. But given how Francisco suddenly backed out of the wedding just days before and disappeared completely, the court found his actions to be reckless and hurtful enough to justify the award. Still, the Supreme Court decided to reduce the moral and exemplary damages from 25,000 pesos to 15,000 pesos. With that adjustment, the rest of the lower court's decision was upheld.